So the High Court in Gauteng Division has ruled that energy regulator Nersa's decision to approve City Power's hike in electricity tariffs for 2019-2020 was irrational, irregular and unlawful. The decision was therefore set aside. The court gave Nersa a year to develop a new methodology in compliance with the relevant legislation. For more on this, we're joined by Steve Jardine, the Managing Director of non-profit entity Casting, Forging and Machining Cluster of South Africa. Their organization is one of 4 that actually took this to the courts. Thank you very much, Steve, for availing yourself this afternoon. Maybe let's start with a bit of context. What brought this onto your radar?
This comes a long way, and one of the challenges we sit with is we keep on being told as manufacturers that we need to be competitive. But yet when we look at the cost of electricity into our manufactured costs, it's becoming a much bigger portion of our total cost than what we would like, and it's making us very uncompetitive. So we've been very worried about the ability to actually stay in the market. We've got a lot of foreign competition, so we've had to try and deal with things differently, and we certainly think it's been important not only for job creation but also for South African expansion in the manufacturing sector.
Help us understand what the court ruling has said about Nersa.
Well, essentially, one of the problems that we faced is that Nersa has been using a guideline methodology which really has tried to find a crutch, because for years they're supposed to have utilized a cost of supply model rather than anything else, and that all tariffs should then reflect the costs of the business. But what's happened is that the way that they've actually come to benchmarking over the years has been really to stack up information from other municipalities, put them together. It was supposed to flatten the pricing of electricity between different municipalities. But what's actually happened is over the years, the cost variation in the tariffs between various municipalities has become astronomical. And one of the reasons why we want to actually be involved is for many businesses, they find that they're paying maybe as much as 40 to 50% more for electricity supplied by a municipality, in this instance, the city of Johannesburg, versus if they bought it from Eskom. And we don't think that's fair.
The court pointed out that licenses were supposed to have done cost of supply studies as far back as 2013, and therefore at least every 5 years, or when there were structural changes in their businesses. Meaning what, essentially?
Well, essentially, when one looks at the regulations and the Act itself, it's quite clear in terms of what we saw the municipalities need to be doing. And that is that in the electricity business itself, it should be ring-fenced. We shouldn't be subsidizing other things with our money that we generate with electricity, but we know that they all do. And in that process, what happens is that you've got different categories that are actually formed for each different municipality. They're not necessarily the same, but for instance, you might have industrial, domestic, business, and so forth and so on, maybe some agriculture as well. And for each of those different categories, you've got different costs in order to get the electricity to the user. So in our instance, we would take a view that would be that for manufacturing, it's not very costly to supply us because a lot of the infrastructure is already there, and it's very structured to very, very centralized locations. Whereas if you're taking it to a farm, for instance, on the other side of the equation, you would have a long way to go, and you would only have 1 or 2 recipients on the far end of the cabling that's laid down. So it's really trying to get an agreement in terms of, if you are one of those exceptional outliers, how much do you pay versus somebody who's actually got a different business model to yours. And the way that it's supposed to be done is the costs of supply to each category need to be worked out. So the ruling was quite simple, is that the information the city of Johannesburg provided to Nersa was insufficient for them to have actually come up with a lawful tariff. They quite simply have been asking for the information for years now. It's not as though it hasn't been requested. but the municipalities have just not been compliant. So I think the judgment is very, very clear in many, many different aspects that, we need to bolster up what it is that Nersa should actually do. And whilst it doesn't take us to a judgment which says this is what Nersa have to do going forward, which we certainly asked for, it does mean that, I think the Nersa team have been given a very, very clear idea of what goes and what doesn't go.
Stephen, so the consumer categories include households, business, or industry. As you mentioned, the judgment does not say what Nersa has to do, but the court has ordered that the applicants, being yourselves and City Power, get together to settle the dispute regarding that 2019-2020 tariffs by mutual agreement. What is it that you want to see? Would you like, what is it when you get your money back? Yeah. Let's put it simply. Do you want your money back?
Yeah, I don't think it's money back necessarily, because what we did is, as part of our dispute, is we paid them what we thought we should pay them. And as I mentioned, the kind of excess is huge. So as a result of it, we didn't believe that we were getting a good, fair deal at the price that they were asking us to pay. So we gave them a figure, we declared a dispute. And in actual fact, we are sitting with money in our kitty, which arguably might need to be repaid back to the municipality if the tariff that we all agree on is actually fair and equitable to the parties. And then either whoever's short paid will need to be getting the money back from the other party. So it's amicable. We certainly have kept the money aside. We made very clear representations right at the very beginning is that we didn't think it was fair, but yet once a fair tariff was actually agreed, we would then pay whatever was needed. So, we fully expect to comply with whatever the outcome is from that discussion.
That Nersa's methodology comes into question, and there's a category there that includes households. What is the consequence for the everyday South African?
Well, I think the courts made it quite clear is that they weren't prepared to go backwards. So the judgment really affected the 2019-20 tariffs. That was where we initiated our concern. And I think the judge has made it as clear as she can in order to make sure that we as normal society can understand it's not really going to have any impact on us at all. So the real impact is really on just those parties that we agreed to be at the table, I suppose, in the court's environment. But for the rest of the Joburg citizens, I don't think that there's anything that they need to worry about at this stage. There will be new tariffs coming in the future. So we are currently in the 2022-2023 phase. And there's separate legislation which is going to have to be drafted and new regulations put in place and so forth around the way that we look at electricity pricing. There's a separate case that was heard a couple of months ago which actually focused more in on the guidelines themselves and the way that the methodology is actually applied. So Nersa certainly has got two very distinct messages that are very clear to them in terms of what they have to do going forward. But there shouldn't be any disruption to normal day life for the rest of us for now.
Steve, thank you very much for availing yourself this afternoon. Steve Jardine is the Managing Director of Casting, Forging and Machining Cluster of South Africa.